Today we'll be reviewing the Supreme Court case of NASA versus Nelson and discussing the constitutional rights to informational privacy. The National Aeronautics and Space Administration has played a major role in the advancement of our country for nearly 64 years. From the very first Mercury rockets, to rovers landing on Mars, to the recent Artemis mission that launched to the moon, NASA continues to surprise and impress as it leads the United States into a new era of human space exploration. The main operating base of NASA is located in Cape Canaveral, Florida. Mission Control is located in Houston, Texas. Ames Research Center in Silicon Valley, California, and the Jet Propulsion Laboratory in Pasadena, California, is the most important among all of these facilities. Let's get into the details of the case. Although NASA does own the Jet Propulsion Laboratory, it is operated by the California Institute of Technology, better known as CalTech. NASA has a workforce of both federal civilians and government employees, but both are hired by private contractors. In January of 2007, the government started requiring background checks for private contractors, so NASA modified its contract with CalTech to include a new standardized questionnaire, which required all employees of JPL to complete, which included authorization to release all personal information, or else they would be voluntarily terminated. The defendant of this case is NASA, and the plaintiff of this case is Robert M. Nelson, who was the JPL's chief scientist at the time, also including the 27 other employees at JPL who sued NASA, arguing that their rights to informational privacy were violated by this questionnaire. The case began in the lower U.S. District Court, then moved to the Ninth Circuit Court in San Francisco, then all the way to Washington, D.C. for the final Supreme Court ruling. The District Court declined to issue a preliminary injunction, but the Court of Appeals for the Ninth Circuit reversed, holding that the drug treatment or counseling question furthered no legitimate interest and was thus likely to be held unconstitutional. Neil Kumar Kutal, an American lawyer and professor of national security law at Georgetown University Law Center, was the main spokesperson representing Nelson and the 27 JPL employees during the Supreme Court case oral argument debate that took place on October 5, 2010.
Extent, Justice Alito, that they are radiating far beyond what private employers do in terms of asking about eating habits and the like, I do think that that there may be some limits. The court doesn't need to confront that here. It simply needs to look at the Ninth Circuit's decision, which recognized a broad freestanding right against informational collection of its employees, to make sure and realize that that is a serious problem for the way the government does business.
Section 17 of this questionnaire is the reason why this case exists at all. Section 17 asks whether the employee had used illegal drugs in the last year, and if so, whether the employee had received any drug treatment or counseling.
Is it your argument that the government can collect whatever information it wants from private individuals so long as the information is not publicly disseminated?
No, that's not our position. Our position here is that the government can collect information so long as it is not disseminated in the employment context.
In other words, this would have been a very different case if the government offered employees an opportunity to share information about their medical treatment or psychological counseling rather than demanding it. Notwithstanding this, the Privacy Act of 1974 provided safeguards against public disclosure of the information, but the records had to be relevant and necessary to accomplish a purpose authorized by law and are subject to several exceptions. JPL employees claimed that NASA had not demonstrated on this record an adequate justification for seeking such highly personal and intimate information in the past, so why should they succumb to it? The Supreme Court answered by citing a document written by the Department of Homeland Security way back in August of 2004 that claims the federal government is fully within the rights of the Constitution to secure reliable forms of identifications from employees and contractors. The employees at JPL had a good reason to refuse submitting personal information, but the U.S. Constitution had the final say in this case, and the Supreme Court issued their final verdict on the 19th of January 2011, concluding that the government's inquiries do not violate a constitutional right to informational privacy. With a unanimous decision by the Supreme Court and a verdict of constitutional, NASA is crowned as the winner in this Supreme Court case.